Hello, niye yapıyorsun Can?
1-2. Good morning, all. It's 29 minutes past 9 on this chilly Monday morning. We are ready to start the day's proceedings. Please make sure that your cell phones are off, your devices are on silent, so that they don't disturb the proceedings. Thank you.
Good morning, Mr. Shaskalsin. Good morning, Ms. Sigels Ngube. Good morning, Mr. Ramatsekisa.
Good morning.
Good morning, Mr. Adams.
Good morning, Justice.
Morning, Chair. Chair, we had hoped to be questioning Mr. Adams today, but unfortunately, we're going to ask for his questioning to stand down until the 19th. The background to our request is that although we have been requesting a statement from Mr. Adams since the 25th of October last year, it finally arrived after 9 o'clock last night. And I think it's important for the public to understand how the Commission operates, because there's this sort of sense that we all sort of just arrive and we can just start questioning and operating instantly because we can integrate all of the information. We know what we want to ask, we know what we don't want to ask, we know how we're going to ask it. It doesn't work that way. You, Chair, and your co-commissioners have to read a statement, have to prepare before a witness is called, so you understand what the witness is going to say, you understand what issues you have. We have to plan our line of questioning in the line of what the witness says. It's simply not possible to do that when the statement arrives essentially 12 hours before the witness starts testifying. And Mr. Adams is an important witness, and we would not be doing justice to this process if we just kicked off and blundered on the basis of a statement that we received last night after 9 o'clock. So we've spoken with Mr. Adams and his legal team. Mr. Adams is available on the 19th. We now have a statement from Mr. Adams. And we would ask that the matter stand down to the 19th of August.
Also, Mr. Adams is legally represented, you say?
Sorry. Not Mr. Adams as legal representatives. I'm sorry. We've spoken to Mr. Adams himself.
All right. And you said the statement was sought from him when?
Well, the first Rule 3 went out to him on the 3rd of August. And then there was, 3rd of October last year. And then a response was sought by 25 October last year. There is a long and lengthy correspondence running through from October last year, and then it starts to accelerate through April, May, June, July.
Which was about what?
Which was about getting the statement and getting a response to the Rule 3. Where that correspondence finally ended was that our last offer was an agreement that the statement could be filed by Thursday last week, which we thought was, we could accommodate Thursday because we could then print on Friday, give the commissioners copies to read over the weekend. And eventually the affidavit came in late last night. I can take the commission through the correspondence. I'm not sure what would be gained by that.
I don't think it's necessary unless Mr. Adams suggests something contrary to what you have said. No, it's not necessary. Perhaps let us hear from Mr. Adams. Is it correct, Mr. Adams, that you received a Rule 3 notice which required of you to file a statement in October of 2025?
Good morning, Commissioners. Parliament can confirm that I have a very problematic laptop. And my laptop was either in for repairs or frozen. And when I became aware of the emails, it was, I really don't want to lie. I
No,
think around about March.
you would not have to lie, so
No,
you don't
no.
even need to.
No, Commissioner, at any rate, I was aware of the Roof 3 a few months ago. But
What's a few months ago?
I think 3 months ago, 4 months ago, when I became aware of it. I had not noticed it in October.
Surely this is something very important. You cannot be as unspecific as you are. When did you first become aware of the Rule 3 notice?
If you're going to ask me for a date right here, Justice, I really wouldn't be able to give you one, but it was a few months ago. But I'm under the impression that I will be getting more questions because people are mentioning me every day, so I was waiting for that. And Honourable Jackelson is 100% right in his assessment. But eventually, I saw that I wasn't going to get a subpoena, and that is why I emailed the Commission.
Is the laptop you are talking about the same laptop you are using for your parliamentary business?
It is.
So are you telling us that you are able to function in Parliament with a laptop that's giving you the problems that you are telling us now?
I am struggling with it.
And how are you able to function at Parliament?
Well, half the times I don't. Half the times I have to walk to people for information or call up for information.
Don't you have IT people who can
We
sort
do.
out your laptop?
They do sort it out for me regularly. It works for a few days and then it just kicks in again.
I find that very hard to believe, Mr. Adams.
It can be confirmed by Parliament.
I
Justice.
find that very hard to believe.
I would too.
That from October last year is only about 3 months back that you became aware that you got a Rule 3 notice from this commission. I find that very hard to believe. Are you telling us the truth?
100% Justice.
And is this the case also with everything else you received from Parliament? From
Yes.
October last year until about 3 months ago, you did not receive anything from Parliament?
Justice Madlanga, I never said that. I'm saying that the laptop freezes on a daily basis. And therefore, if I may, therefore, whenever I take it out my bag, I normally have to go to IT. It will work for a day or two and it will start again. So
You say you never said what I just suggested to you now. If you did not get the Commission's Rule 3 notice from October until only about 3 months ago, that should be true of communications from Parliament as well. It's on that basis that I've just said what I said to you now.
Yes, Justice, that is what I'm agreeing with you.
So from October, I thought you were saying that's not what you said.
No, sorry. It's not even from October, Justice. It's been for about 18 months that I'm struggling with this device.
Yeah, I'm not concerned about anything else. I'm concerned about October to today. For you to only give to the Commission communication, or rather your statement, which was required from October of last year, for you to only give that statement to the Commission after 9 p.m. last night. And the only excuse you have is that you have difficulties with your laptop. All right, I don't believe that. I find it hard to believe that. Because otherwise, you should not be operational at all as a parliamentarian. Okay, let's move on. Now, about 3 months back, you became aware that a statement was required of you. So, according to what you say, which is hard to believe, you have had 3 months and we only get your statement after 9 p.m. last night. What excuse do you have for that?
There is no excuse, Justice, because when I emailed the Commission about 2 weeks ago, I asked for a date. I was given the date of the 11th. I emailed back. I said to them that it is voter registration, 6th, 7th, 8th. I essentially have 5 days to complete this thing. Can I have a slightly later date? The Commission...
Why would you have asked for a date? You would have seen from the communication which you got 3 months back that the statement was required from October last year already. Why would you have asked for a date? 3 months back, you become aware that, oh, for such a long time, a statement was required from me. You still ask for a date instead of saying, wow, I'm very late already, and quickly putting your statement together. Why only a week or a couple of weeks back do you ask for a date only then?
The commission asked me 3 questions, Judge, and I felt that I could offer much more than 3 questions, which is why I asked for a date. When the date was proposed on the 11th, I emailed back, I said, can I have just a little bit more time? And I was told, no, the 11th is the only available date. I moved heaven and earth. I sat up nights to conclude this thing. And I'm not saying that I'm doing that what I did was right. But what I'm saying is I tried my level best to meet the deadline of Thursday. I couldn't.
What I will say, and I will stop here, what I will say is it seems to me that you are not taking this commission seriously. And starting from now and going forward, you should not treat this commission the way you have thus far, because every and anything you've said thus far is just totally unbelievable. I do not believe it. This should mean that you cannot function at Parliament as a parliamentarian. And it also suggests that you are not even taking the people that you are supposed to serve seriously, if for as long as you suggest is the case. You have been using a laptop that you basically cannot use. You are not taking us as a commission seriously, and I would dare say you are not even taking the people that you are supposed to serve seriously. Starting from now going forward, you must take this commission seriously, Mr. Adams. What do we do now, Mr. Shaskalsin?
Well, Chair, we have the statement. The next open slot, or the next slot that can be made open, is the 19th of August. And Mr. Adams can come on the 19th of August. I'd ask that we postpone to the 19th of August.
Yes. For the record, let me just repeat something that you yourself already said, Mr. Shaskalsin, which is that it is not practical for us to hear Mr. Adams's evidence now. People who follow the Commission's proceedings will have heard that all the time. We refer to what we have read in the statements of witnesses because we prepare ahead of time. If a statement was given or furnished to the Commission after 9 p.m., there is no way that that statement would then be forwarded to us commissioners for us to prepare. That's true of the evidence leaders as well, actually, because they too need to prepare. So practically, it is not possible to hear Mr. Adams's evidence today. For that reason, as Mr. Shaskalson requests, the hearing of his testimony Mr. Adams's testimony must be postponed. 19
August, Chair.
19 August. Mr. Adams, the hearing of your testimony is postponed to 19 August 2026. You are excused until then. Thank you.
Thank you.
You are excused.
Chair, can I be excused?
You are excused, Mr. Shaskalson.
Yes.
Let's have a short stand down. We'll hear from you when you are ready to.
Thank you, Chair.
Yeah. Let's adjourn.
Good morning again, Chair.
Yes.
Chair, we're ready to proceed with Ms. Ramsami's evidence from where we left off last week, Wednesday.
Good morning, Ms. Ramsamy.
Morning, Chair. Morning, Commissioners. Please bear with me. I have a little bit of flu.
Chair, when we adjourned, we were about to start the topic on page 16 of the supplementary statement, which is the Medicare 24 investigation. But I did indicate that the witness was going to provide additional documentation, and some of it does deal with topics that we've already covered. So we just want to address those topics, and when necessary to refer the commissioners to the relevant supporting documentation in support of her statements in her affidavit. The first, Chair, is regarding an issue that Ms. Ramsamy wants to clarify, which relates to the meeting of 22 January 2025, where the first meeting regarding Operation Diversion was discussed. And there was certain references to the National Commissioner not to inform the National Commissioner about the investigation, and in order for the National Commissioner to somehow be caught in a lie, and this was linked to the Portfolio Committee on Policing. And Ms. Ramsamy just wants to give some clarification on what it is that she's saying regarding that aspect, and also that her evidence is not that anyone within the parliamentary committee was complicit in some plan to catch the National Commissioner into lying to the Portfolio Committee. What she seeks to show the commissioners is that this is a discussion that was held within IDAC. It was, as far as she's aware, discussions that were exclusively amongst IDAC members. It may have been that some parliamentary members, Committee on Policing members, were involved in that, but she doesn't have evidence of that. She also wants to deal with the timeline to demonstrate or to just show the commissioners that when meetings were held regarding Mr. Ian Cameron specifically and certain information that he was going to give IDAC, the very next day his statement is filed and prepared by Mr. Brian Padiachi, who commissions the affidavit as well. So she just wants to put the facts before the commissioners, and whatever conclusions are drawn from that, she doesn't draw conclusions, but the timing of it is significant given that there is this discussion about catching the commissioner in a lie. There's discussion about minutes of meetings, and then Mr. Ian Cameron signs or submits an affidavit, commissions an affidavit on the 9th of April, where he refers to minutes of meetings and he refers to the National Commissioner having misled the parliamentary committee. That's really all that she wants to bring to the fore. And I want to assist her with that because of the documentation that she'll be referring to, and that we can deal with it methodically so that the picture can be fully put out. Because I think when she was dealing with it, she was talking about it within the context of the 2022 January meeting. She didn't really follow through on the thread of that specific topic, so she wants to deal with it now. Ms. Ramsamy, for that, can we go to, the first thing is about the meeting of 22 January 2025 and the ID initiating that meeting. We initially didn't have the email from the ID calling on that meeting. We do now have that, Chair, and that should be at file 10, page 419. I think it's called file 10-2. Yes, file 10, part 2. Page 419. Ms. Ramsamy, do you have the email?
Yes, I do.
And this is an email on the 16th of January 2025 at 8:51 from Advocate Johnson she copies herself, she sends it to herself, Mr. Perumal, Mr. Sesoko, Mr. Rapesu, and you, and she CCs her PA, I think it is Ms.
Correct.
Ino, who you refer to as Ino. Now, the subject is diversion. When is the reference to a meeting that's to be held on Wednesday, January 22nd, from 12 till 2:30 at the SARS Boardroom 2.2. Can you read the message?
Dear colleagues, I want a full briefing. Who did what? Who have you seen? What are you dealing with? Kindly prepare a presentation and make sure my office receives it no later than Monday, the 20th.
Okay, and so that is the meeting that gets called on the 22nd. We know that Mr. Perumal submits a draft presentation, which we've been through. You also work on that presentation at the prosecutorial input.
Correct.
And submit that to Advocate Johnson and Mr. Sesoko on the 19th of January in preparation for that meeting.
Correct.
Now, insofar as whether Advocate Johnson had any input on that presentation, do you know whether she did?
She did. Advocate Johnson, at the presentation on the 22nd, I had printed a version, her edited version of the presentation with her input and her additions and subtractions, and had given us hard copies, whereas Mr. Perumal and myself had submitted soft copies via email.
Okay, so Advocate Johnson worked off the version that you gave her, and did she send it to the team or just presented hard copies on the day?
She presented hard copies on the day.
Okay. Commissioners, we have been given a copy of that well, actually the original with Advocate Johnson's manuscript additions made onto the version that she gave the members on the day. So she was aware of what was contained in the presentation before the presentation started on the 22nd of January.
Correct.
Okay. Now, you then testified about what happened in that meeting, and specifically in reference to file 11, page 5, which is a note by you about the National Commissioner, file 11, page 5, which is the handwritten notes.
Yes, Advocate Johnson made specific or made a specific statement saying,
Can we just get to it first then?
File 11 page.
Page 5. And that is the note. Your evidence was that during that meeting, Advocate Johnson then said, we're not going to tell the National Commissioner about the investigation so that he can be caught in a lie should he appear before the Parliamentary Portfolio Committee on Policing.
correct.
Okay. Now you later...
And this is your note. Is it her note?
No, I'm writing down what Advocate Johnson is saying in the meeting.
Thank you.
We'll come back to the reference to the IGI again later, but then later in your evidence, you also testified that there was a discussion between you and Mr. Perumal, and you said somewhere in February or March, where he mentioned that the National Commissioner will be appearing before the Portfolio Committee soon, and he'll commit perjury. Or something to that effect.
Something to that effect, correct. It would have been either the 9th of February or the 28th of March. It was one of those two conversations. But in my recollection, I think it was closer towards April. So it would have been around the 28th of March, where the conversation was, he's going to lie and it's going to be a perjury charge at the Portfolio Committee, him being NASCOM.
And just to be clear, that was a discussion not with Advocate Johnson, it was with you and Mr. Perumal.
Correct.
Okay. Commissioners, there is a reference to that evidence that the witness gave on the 5th of August on page 119 of the transcript, which I just had a look at. And what she says is, it's in response to Advocate Baloy's question about before you leave your note at page 5, did Advocate Johnson say why the National Commissioner should be left to lie? What was the plan, the idea behind let him go lie to Parliament, and then what? And then Ms. Ramsamy says, like I said in Statement 1, Commissioners, it looked and obviously became evident that there was a line of march, and that line of march was to get General Kumalo and General Masimola in an accused box. And so obviously, at some point, there was talk about if he lies at Portfolio Committee, and this was again well after. I think this is the February or March, and this was just between Yusei Pariachi and myself and Mr. Perumal, where if he lies, we can at least charge him for perjury. So the clarification that I want from you is that Advocate Johnson didn't mention anything about the Commissioner being charged on perjury in January 22, at the 22 January meeting. The perjury issue arose in the conversation that you had later on with Mr. Perumal.
Correct.
Okay.
Advocate Johnson's words were, don't tell him, let him go lie. That was...
Morning.
Morning.
Can I just
Commissioner.
clarify something? For the plan to work, they must have known what the National Commissioner was going to be asked, or what was going to be discussed with the National Commissioner at the ad hoc. And they must have known that if he gives a certain answer, it will be untruthful and could lead to adverse consequences. I mean, how did all that work? I mean, how did they know that he will go there and he will be asked a certain question, and if he gives a particular answer, it will be a lie? How would they have known that? Because this is January 2025. It's very early in the year.
Commissioner, I also had those questions, and I did earlier, I think it was on my evidence on the 29th of July, where I said that Advocate Johnson, Mr. Perumal and Mr. Padiachi would speak in undertones. They would understand what the other person is saying, and the rest of us were left to catch up. So when I analyzed the January conversation or statement by Advocate Johnson, and then the later conversation with Mr. Perumal, and then the consultation or the meeting that took place between myself, Mr. Perumal, and Mr. Padiachi on the 8th of April. I then put through the link that there was communication between IDAC and the Portfolio Committee, or certain members of the Portfolio Committee. I'm not saying that I have concrete proof. I'm saying that it's the inference that I drew.
Now, can we go then to file 11, page 16? And perhaps if we start at page 13, because this will show us that this was the meeting at Fire and Ice. On page 13, 2025/4/8, and it's D, B, and me, which is Mr. Perumal, Mr. Pariachi, and you.
Correct.
Okay, and there's various discussions about the operation, but if we can go to page 16, you will see there's another note on there's a page 16, it says Ian Cameron, and then it says minutes.
Correct.
Okay, and do you recall what you were recording there insofar as minutes and Mr. Cameron?
If I had been given detail, I would have written it down as per the remainder from page 13. It's very clear I was writing pretty much everything down. It was a brief passing conversation that said they were seeing Ian Cameron to get the minutes. And this was on the 8th of April. If anything more was said, I would have noted it down, but that was basically what was said.
And those minutes, would those have been minutes of the Portfolio Committee meeting?
I later found out that it was the minutes of the Portfolio Committee as per the Mr. Cameron's statement on the 9th of April.
And they didn't say why they got the minutes of that meeting from, or they would be getting that minutes, the minutes of those meetings?
At this point, Commissioners and Chair, I was distrusted. I was not kept in the loop. And I explained that at this point they only gave me. There's a saying: you keep a mushroom in the dark and feed it. So it's basically, they were using me to enroll the Lushaba matter, and that was the purpose. And I read the WhatsApps on last week, where on the 5th of April, Mr. Perumal called me to say that this is an urgent meeting, it has to take place. And that is why I drove to Fire and Ice to have the meeting with him. So it's a possibility that they didn't even want me to know about this. It just happened, and it came out.
And when you were asked about the meeting, or to attend a meeting on the 5th of April, the Portfolio Committee meeting had taken place on the 2nd of April.
I did Google last week after testifying. Yes, it did take place on the 2nd of April.
If we can go to file 7, which is Mr. Cameron's statement at 2820. Page 2820. And while we're getting to that statement, do you know why Mr. Cameron prepared the statement as the A6?
No, I do not. I also found it unnecessary and irrelevant.
Do you know for which matter it was, for which case?
If memory serves, it was in the, it was for the purposes of the Mokwele matter and for the arrest of what they called the Kumalo Masiamula matter.
So
and
the
then also the
appointments
Kumalo Madondo matter. So yes, the appointments.
relating
and the
to
vetting.
crime intelligence appointments.
Correct, and the vetting of those persons appointed.
Can I just ask, do you know from those minutes whether the Mukwele, the vetting issues were discussed in that portfolio committee meeting?
As the
Because when you look at paragraph 10, he ventures that he believes they have lied, or that
Yes,
they've lied. Do you know if there was such a discussion?
To date, the prosecutors have not received those minutes.
Oh.
If I can refer you to paragraph 5 of the statement at 2820, that's where he mentions that as chairperson, I convened a portfolio committee meeting on Wednesday, 2025-0402, which would be 2 April 2025, online with members of the committee, senior managers from the Office of the Minister of Police and senior management of the SAPS, led by General S.F. Masimola. And then on the next page, 2821, paragraph 6, for ease of reference, I attach here to the audio recording, video recording, and minutes of the said meeting, which includes replies to questions posed by committee members and the replies thereto by SAP's senior management. Then, so he does say that he's attaching the video recording and minutes, but you say you haven't seen those minutes and you haven't seen a report?
The investigators, Mr. Padiachi and Mr. Perumal, have not provided it to us.
Okay. And you don't know if he did in fact provide it? I mean, it's referenced in his statement, but we don't know if he actually did provide it.
No, I cannot confirm that he provided it.
We know Mr. Padiachi took the statement in Cape Town on the 9th, so he would have presumably given it to him if he did. If it was provided, or it would be annexed to the statement?
It should have been where it says paragraph 6, I annex here too. It should have been marked as an annexure too. And generally it would have been either in a sealed envelope or in an exhibit bag for it to be annexed to a statement.
Can I just ask a process issue? When IDEC receives documents, such as a statement and annexures and any other document, is there not a system of recording what has been received and from whom?
In all other projects, yes. there is a system in place. In all the other projects I've worked on, except for these two that I'm discussing, there is a system in place.
Thank you.
And then at paragraph 7, Mr. Cameron says, there have been several media press releases and on social digital platforms where allegations of corruption within the Crime Intelligence Division have surfaced. The committee was therefore focused on addressing some of these allegations, as will be evident from the minutes. So again, there's a reference to the minutes. We know in your note on the 8th of April, there's a discussion about minutes from Mr. Ian Cameron.
Correct.
But we don't know whether those minutes were actually provided by him. But we do know that on the 8th, before the statement is made or commissioned, Mr. Perumal is referring to Ian Cameron and minutes.
Correct.
Okay. Now, at paragraph 8, he says some committee members were not satisfied with the SAP's management responses. However, in the absence of factual evidence, I intervened and closed the agenda point and moved to the next item on the agenda. And at paragraph 10, he says, I suspect the senior management of the SAPs, led by General Masemola, misled the portfolio committee in answer to several questions posed to them. To confirm exactly where the committee was misled, it will be prudent for the committee's recording of the meeting to be compared with the evidence available in the relevant crime intelligence files. Do you know what crime intelligence files he is referring to?
I would, my understanding of that would be the dockets that IDAC was in possession of and investigating.
But when you say dockets, are you referring to Mr. Adams' dockets, or are you referring to the contents in that dockets that contain crime intelligence files? What are you referring to?
The contents.
Okay. But you...
But why only dockets? I mean, I would imagine crime intelligence should have a whole lot of documents on a variety of issues that might have been relevant to what was being raised by the portfolio committee, but not only or necessarily dockets.
It's open to interpretation, and I think the deponent would be best suited to explain. But with regards to evidence available in relevant crime intelligence files.
But do you accept the wider possibility that I'm positing to you?
I do.
Thank you.
Okay.
Ms. Ngube, does this not refer to vetting? Are these not vetting files that are not being referred to?
Well, we don't know, Commissioner Kumalo. I mean, he speaks about appointments. I think it is... But we don't know
That's
what
why
it...
I am asking the question, because if it talks about crime intelligence files, and then it can relate to the dockets that Mr. Adams opened.
Yes, I mean, the witness doesn't know. She was just, I guess, offering, but you don't know.
No,
and
I cannot confirm.
Do you know whether Mr. Cameron gave Mr. Perumal or Mr. Pariachi any crime intelligence files?
No, I don't.
And
save for this affidavit, we didn't even receive the minutes.
You didn't see the minutes in the docket where this statement is supposed to be, because this statement is labeled A6, which means it's part of a docket.
My understanding is that this is A6 in the Mokwele matter docket.
Okay, so it's A6 in the Mokwele docket, and so therefore, if there were any documents that emanated from the statement or were included with the statement, it would have been in that docket.
Correct.
And you didn't see any crime intelligence files in the docket?
No. I had explained previously that we were working off digital copies of the docket, and when I was perusing the docket in June to make an evidential assessment, it was, the minutes were not there.
Okay. And the recording as well, not in?
No, there was nothing.
Okay.
Can I just ask, still again, in a way it's a process issue. At this point, are you the prosecutor in charge of the matter?
At this point, it's now myself and Advocate Schlatzweiler.
Okay. And as the prosecutor, when you receive, and my question assumes that you received this affidavit at the time, around the period that it was taken. It's not something that you see now, today, as you're testifying?
On the 19th of June, I received it, yes.
Okay. Do you not ask where are the annexures? Because I assume you read the affidavit when you get it. It's part of, you say it's part of a docket that you're going to receive, that you're going to be discovering. On the face of it, clearly, without the annexures, it's incomplete, and so you're going to be discovering an incomplete set of documents if this is what all you're discovering. Don't you, as a prosecutor, say, where are the annexures? We have to see them, but more importantly, we need to disclose them. What happened here?
Ordinarily, we would. If I may just digress as to what happened around that period when I received the docket. Ordinarily, we would, but on the 19th of June, 2025, I had received the electronic copy. I had read the docket, and I found that there was no merit for enrollment. I found that there was no prima facie case. So I had started preparing a memo, because irrespective of this statement, the other statements held no element of an offense, or spoke to no offense that could be taken to court, so no prima facie case. So I had started drafting a memo, which the commissioners will see shortly, where you go statement by statement, problem by problem, and then submissions. And you would recommend that there's no prima facie case. Unfortunately, I came down with bronchitis, severe bronchitis. I was actually going for physio to loosen the phlegm in my chest. And I didn't finish the memo. While I was on sick leave, I received a call from someone in the office, and then a WhatsApp saying, hey, aren't you dealing with the crime intelligence matters? Your matter's in court. And when I put the TV on, I see that the Mukwele arrest has taken place. So it was a matter of, I was in the process of doing the memo, and had I not been sick, I would have completed and submitted the memo.
You would have asked about
I
these
would have
annexures
made
that are
reference
not
to the
there.
fact that these things are not in the copy of the docket that we received.
Okay. Thank you. Thanks, Mr.
Mr. Obe, the reason why I thought this has to do with the vetting issue and specifically the Madondo issue, because the statement is A6, but if you go to A1 and A2, A3, A4, A5, 2611 is the A1, followed by the Adams affidavit relating to the lateral transfer of General Madondo, and then they follow in that sequence. So even the affidavit before Mr. Cameron's is the affidavit of General Khan, which also talks to so it's not the Mukwele issue, it's the vetting issue and the Madondo issue, the way it looks to me, and I could be wrong, but the sequence of documents suggests that it relates to that transfer of General Madondo. And the Cameron statement, Mr. Cameron statement, in that paragraph that we were looking at, where he talks about relevant crime intelligence files, it must be referring to that subject.
Do you want to comment?
It's a possibility. However, I do remember seeing Ian Cameron's statement in the Mukwele docket. I stand to be corrected, but memory serves that it was, in fact, in that docket.
And when you had the discussion with Mr. Perumal at Fire and Ice, when you had that meeting, did, if you go to page 13, you were discussing all the matters, basically. It wasn't just the vetting matter.
You're talking about the 8th of April?
Yes, on page 13.
If you look at the notes, it's predominantly the housebreaking matter.
Okay.
It's Lushaba's matter, predominantly, until such point as you reach page 16, where Ian Cameron pops up.
And was it, I mean, you weren't really involved in that process. One of your complaints was that you were not being included or being informed when consultations were being held with witnesses or any person related to these cases that you were involved in.
Correct.
And so when you get told that Mr. Cameron is going to provide minutes or there's a reference to minutes, what is it, do you say anything to them? Is there a discussion about it? Are they mentioning that they're busy getting a statement from him?
No, I didn't ask any questions because I could see that they were uncomfortable that the name was mentioned, and it stopped there.
Okay, and then we know that on the 9th, when the statement is then prepared, there's the WhatsApp conversation where there's an indication that Mr. Cameron had submitted his affidavit, or was busy with his affidavit.
Correct.
And that was from, it's a conversation between Mr. Perumal and Advocate Johnson, which he sends to you.
Correct.
Okay. Is there anything else you want to address on that issue related to Mr. Cameron's affidavit?
It's safe to say that I didn't say that he was part of the narrative or he had included himself in the narrative. My statement was very clear. The inference I drew from all the events that transpired leading to his affidavit and me being informed about his affidavit, as well as the fact that there's a message between Mr. Perumal and Ms. Advocate Johnson indicating that he's on board. So the inference I drew was what I stated.
Okay. Then can we move on to the next topic where we just have to close out? It's the Section 28(1) authorization on the Mokwele matter, which is where we finished off your evidence last week where you indicated that you didn't prepare that authorization. Following on that evidence, I had asked you to go and look at your emails to see if you had ever sent Advocate Johnson any Section 28(1) authorization in May. I think I asked you to look for that specific, whether in May you had sent a 28(1). We know that you sent the Madlanga, the Medicare 24 Section 28(1) application. But I asked you specifically to go and look for the Mokwele or any crime intelligence matters, and you weren't able to find any emails.
From May, no.
Okay. And we then tried to establish where the date of the 30th of May could have come from, given that you had only sent the, what you refer to as the umbrella Section 28(1) application on the 3rd of June.
Correct.
And Commissioners, the witness had previously sent us the trail of emails between her and the project manager where he mentions the Section 28 authorizations, but she sent us the last email in the chain which wouldn't have an attachment. So we've asked her to send each email individually, and when she sent the first email, there were attachments, and we would like to deal with
The old 10.
Part 2.
Part 2.
5?
10, yeah, 548, Part 2.
Thank you.
File 10, Part 2. So at 548, at the bottom of 548, there's an email from Mr. Tlale to you and to Advocate Hlashwayo on the 16th of July, 2025, with the subject Section 28 authorizations. And he says, "Hi ladies, these are the soft copies of your authorizations." And if we go to 549, we see that there were 6 attachments.
Correct.
For 3 documents for leg 1 and 3 documents for leg 2. Do you recall why he sent you these soft copy authorizations in July 2025?
No, I was actually confused, and I did reply to this email.
Yes, we'll get to your reply, but can we then go to page 550, which is one of the attachments to that email? And Commissioners, what you will see there is Advocate John, it's a document from Advocate Ramsamy to Advocate Johnson dated 30 May 2025. And you'll see that the subject relates to the authorization of diversion leg 1, house-breaking burglary. And this is now where we see the date of 30 May 2025.
Correct.
But this, you had sent an umbrella, section 28 on the 3rd of June, and what you get back in July 2025 is a split section 28.1 application.
Correct.
Did you prepare this document?
No.
Okay. And if we go to 563,
Which document did you not prepare? The one at 550?
550 was not prepared by me.
at 563, there's another document, also with the same 30 May 2025 date, which is then an application for 28-1 for Leg 2, which is the appointment, which is the Mokwele matter.
Correct.
Okay. And this was one of the attachments from Mr. Tlale.
Correct.
Did you prepare this document?
No, this was not prepared by me.
Who prepared the one at 550 and this one, the one at 558? Who prepared them?
The emails confirm that the project manager, Mr. Schlale, prepared them.
Okay. Can we go to page
Can I just-
517? Oh.
Was it unusual that the project manager would prepare a document for you and then such as this and send to you? Because he prepares it and then he sends it to you, I suppose, for you to approve or not to approve. Was it a regular occurrence? Or
No.
is there anything unusual
It's
in
very
the fact
unusual.
that he's done it this way?
Commissioner Baloyi, if we go back to how I was explaining how the process works, it would, I even spoke about the formatting, if you're good with formatting. It's usually prosecutor to DD to project manager to submit to Advocate Johnson. Or if you're not good with formatting, then you would send it to the project manager, as I did on the 3rd of June, for him to format, send back to me, and then it would be submitted. But these documents are not supposed to be done by the project manager.
And that is what you did on the 3rd of June when you sent him your draft with the umbrella section 28.1. You sent it to him and said, please work your magic.
Correct.
And you explained to us that he had to do the formatting.
Yes.
You didn't expect to get a month later two 28.1s that refer to Leg 1 and Leg 2.
Correct.
Okay. And in fact, Advocate Johnson's email on the 3rd of June was saying that she's still working on the section 28 that you had sent her.
Yes.
Okay. And that one had a date of 2 June 2025. It wasn't 30 May.
My apologies. Yes, correct.
You then responded to the email from Mr. Tlale, and that we find on page 579.
My apologies. 579.
Yes, we'll have to read it from the bottom to the top. So at the bottom of the page, we have Mr. Tlale's email where he says, hi ladies, these are the soft copies of your authorizations. And then the email above that, it's from you to him, section 28 authorizations. You say, hi, are these signed? Who did them?
Correct.
Because what you get sent is unsigned 28.1s.
That I
Well,
did
all
not-
the documents are unsigned.
Yeah, which I did not compile, nor did Advocate Schlatzwayo compile.
And so you're asking him who did them.
Correct. I wanted to know are these signed and who did them.
And his response then to you is the email above that. He says, only Leg 1 is signed, which means only housebreaking is signed.
Correct.
I compiled all using your prosecution memos. I need to fix Leg 2 as per ID.
Correct.
And Leg 2 is the Mokwele matter.
Correct.
And so, as at 16 July 2025, he's saying that he still needs to fix the 28.1 in respect of the Mokwele matter. as per the ID.
Which then confirms that as of the 16th of July 2025, there was no 28-1 authorization for the Mokwele matter.
Did you have a discussion with him about it?
I did, and I asked him, I went to his office and I asked him, why is Mokwele in my name? Why is it being submitted in my name? I was on sick leave, and now you're submitting a document in my name where I'm not the prosecutor anymore, and another prosecutor enrolled it. And he just did.
You know why the prosecutor, Ms. Hlachwayo, is copied on these emails?
Because she's the prosecutor that enrolled Mokwele.
And this is almost a month after the arrest.
Correct.
Ms. Siegels, Ms. Ramsamy said when she asked why this document was submitted in her name, he just did this. Do you want to describe
I
that
don't know what to
and
say,
place it on record?
He shrugged.
You shrugged.
He shrugged.
He shrugged.
Yeah.
He lifted his hands in a manner that, was indicative of shrugging.
Correct.
All right, okay.
Okay. And have you, apart from what was flighted at the Commission, which was the 30 May 2025 application and authorization signed by Advocate Johnson with a date 30 May 2025, have you ever seen a Section 28(1) authorization for the Mokwele matter other than the one that was displayed here?
No, there was no signed 28(1) for the Lushaba matter or the Mokwele matter that has been provided to myself or Advocate Hlatswayo.
What was provided by Mr. Tlale sometime in November 2025 was the signed Section 28(2)A authorizations.
Correct.
For both matters.
Correct.
And those are dated?
8 August 2025, and a Section 28(2) is in terms of the Act, it's sort of like a certificate that Advocate Johnson would sign to allow us to prosecute on behalf of the ID. So even that should have been signed prior to.
Can you just explain
Prior to the arrest, you mean?
Prior to the 13th of June and the 25th, 26th of June? Yeah.
Can you just explain where does the 28(2)A fall in the process and who prepares that document? Because I haven't seen any draft from it. Is it just something that Advocate Johnson sends?
With the 27 referral from 2023, I drafted the 28(2) and submitted it for authorization after my deputy director approved the drafting and the contents. So it should have come from the prosecutors.
And that document, is it part of the legislation that there must be the 28(2)A, or is it something that's a practice or procedure in the SOP? Where does it come from? And why do you need it?
Sometimes Advocate Johnson would ask for it, sometimes not. But with the 27 referral, she would. In terms of the Act, Advocate Johnson needs to delegate authority to prosecutors, either deputy director, senior state advocates, to prosecute on behalf of the investigating director. And that is the purpose of a 28(2), to provide us with a certificate to authorize us. It's the same thing as a delegation. So if I was a district court prosecutor and they gave me an acting stint in the regional court, the DDPP of that jurisdiction would issue a certificate of delegation to allow me to prosecute in the regional court. So it's a delegation for us to have permission to or authorization to prosecute.
We're going to include it in
Within IDEC, is this done once off, or is it done per matter?
Like I said, Advocate Johnson, because of the 227 referrals, the first one I knew that I was requested to do one. And so it was the deputy director and I were trying to figure out how to format it and how it was supposed to be worded because we didn't have an example. But it became a standard procedure later on. But like I said, standard procedures were deviated very often according to what Advocate Johnson wanted at the time.
What I'm trying to understand is the delegation to prosecute. Would that not be done once off? Because, for there to be a delegation each time a matter comes up, it sounds quite cumbersome. So would it be a once-off delegation? Or?
We are issued with a delegation. I think we've been issued with 3 different ones now. With Advocate Johnson, it's a certificate that we generally carry with us just in case either a judge or a magistrate wants to see. But that is done, if memory serves, it's done in terms of Section 24 of the NPA Act, not in terms of Section 28.
Okay.
Can I just clarify? And it may be a difference of practice and what the law prescribes. A quick look at 28.2 is authority to investigate, not to prosecute. Were you using it differently?
I'm trying to find my NPA Act. In our exhibit file, do we have the 28?
It was there at some point, I'm not sure. NPA Act?
Have you found it? I see you are paging. Have you found the act?
Section 20.
No.
Can we display it in front of you? You should be able to see it on the screen in front of you. Display.
And whilst you are looking, in any event, with regard to a delegation to prosecute, as I understand it, you and other prosecutors are part of the NPA anyway. So it wouldn't make much sense for there to be a new delegation to prosecute, as it were, if you already have a delegation to prosecute. But please respond directly to the question by Commissioner Baloyi.
Correct. It is to investigate.
Thank you.
Okay. We'll include the email chain regarding the 28.2As in the bundle. For now, we'll just display it. It's an email from Ms. Latwayo on the 12th of November 2025 to Mr. Tlale, copying you, where she's responding to his July email where he says, these are the soft copies for your authorizations. She sends an email to him saying, good morning, Tsepo. I have just realized that Bra Peter is not designated in these matters, more especially leg 2, and currently is the one who is appearing in court. May you kindly add him? And his response is above that. He says, he is, please receive attached. And what he attaches, if you look at the 3rd page, is the Section 28.2A designations, 8 August, you'll see the date is 8 August 2025.
Correct.
And we do have the attachments. The first one, you'll see once it comes up, it again refers to, in the first line, whereas I, Andrea Johnson, the investigating director, on 30 May 2025, have decided to conduct an investigation in terms of Section 28.1A. Again, there's reference to the authorization, which you know nothing of, for 30 May 2025.
Correct.
And was November 2025 the first time that you saw this 28.2A?
Yes, it was the first time that it was emailed to us.
If you look at the 3rd page, it's got the signature date of Advocate Johnson. It's 8 August 2025.
Correct.
Okay. And insofar as the 28(1)A authorization, so we've spoken about the application for authorization. Have you seen this signed, other than the 30 May 2025, that's part of the bundle that was displayed during Advocate Johnson's evidence? Have you seen an authorization for the Mokwele matter other than the 30 May 2025 one?
I saw the one that I sent that wasn't signed on the 3rd of June, and then these, but a signed one from Advocate Johnson was never submitted to us.
28(1).
Correct.
Okay. Only the 30 May 2025 one that was displayed here at the Commission. Now, then, if we can move on to another topic insofar as the Mokwele matter is concerned, and this relates to the evidence of Advocate Serunye regarding the bail amendment and bail application, bail appeal proceedings from September 2025.
Correct.
Now, his evidence, insofar as we know that you were involved somewhat in that process, but you were no longer the prosecutor on the Mokwele matter, or were you still with Ms. Latshwayo?
No, on the 8th of August, Advocate Johnson had separated us completely on the matters. However, with regards to the bail application, I was asked by Advocate Serunye to assist.
Okay, and just to recap that Advocate Serunye gets involved in August.
Correct, on the 8th of August.
Well,
yes.
he was at the first appearance in June, but then his real involvement starts in August 2025. He then sends his trial preparation memo where he raises pertinent questions regarding the case. And your evidence was that when he got involved, there was a voice that you could now go and speak to, somebody that would hear the complaints about what your assessment, you and Ms. Latshwayo, your assessment of the matters are concerned.
Correct.
And he seemed to hold the same views.
Yes.
We know that Mr. Perumal responded to his email, but you didn't respond to his email where he had raised all those questions. And you were copied in that email, you and Ms. Latshwayo. Can you tell us why you didn't respond?
If the Commissioner and Chair would note the times of Mr. Advocate Serunye's emails, it was generally towards the latter part of the afternoon or evening. During the day, Advocate Hlatswayo and myself would sit with Advocate Serunye in his office, and we would dissect all of these things, and we would voice our concerns, and he even testified to the effect that they were not listening, the investigators were not listening to Advocate Hlatswayo and I. So that is why when I testified on the 29th of July, I said when Advocate Serunye started listening to us and taking these things up in writing and asking for answers, it gave us a sense of relief. With regards to the bail question, I was assisting due to Advocate Serunye's health, so we needed all hands on deck. But there are messages with regards to how that transpired.
Yes, we'll get to those messages. I think the first event in that sequence is a meeting that was held on 1 September 2025, which we'll file in file 11, page 74. Chair, perhaps before we continue with this topic, it's maybe best to take the tea adjournment, and we'll continue when we get back.
Let's resume at 11:30. Let's adjourn.
11. We are ready to resume. Please make sure your cell phones are off. Thank you.
Thank you, Chair.
Yes.
And his emails and he's questioning a constant request for the 27 referral. So she addressed that the Mukwele arrest was not that, because in those judgments, it was clear what the quid pro quo would be, even though there wasn't a specific agreement. And yes, the gratification or the quid pro quo would come in effect later on, but it was evident from the relationship what would be expected, versus the Mukwele matter where it's just a mere statement of in the future to do what? So that was the to and fro's that were happening. However, Advocate Johnson then got agitated and took over and wouldn't allow us to speak and laid down the law that these matters are going to proceed and that the investigating officers are going to explain to the prosecutors what the evidence is and how we should interpret it and understand.
That there was a case on the Mukwele matter, or were there other matters discussed?
There were two other matters discussed. In my statement, I later deal with the Madondo Kumalo and the Masiamula Kumalo arrests, which are two separate issues. Advocate Johnson in that meeting indicated that irrespective of what Advocate Schlatzweiler and I had presented to her in July already, those matters will be enrolled.
And we see there you have 3 bullet points. The second bullet point on your note says CI IDAC equals is the state capture. And then the next bullet, circumvented in an arrow in anticipation of. What was she discussing there?
Advocate Johnson was...
That General Labia?
Yes, there's a docket that relates to her on Libya, or they're going to obtain the...
And
what advocates
have to beef up charge sheet in equal corruption. 77.
We just have to.
Do you see it?
Yes. Beef up charge sheet, equal corruption, Mukwele's docket.
So part of the discussion here was to beef up the Mukwele charge sheet to the corruption charge in the Mukwele charge sheet.
With regards to this conversation, it was more...
Sort of towards the end of the page, there's a reference to IGI, page 45 to 75, part 2 report.
Correct.
What is that?
Commissioner Beloy asked me a question last week about IGI, whether an IGI meeting took place. So in order for us to understand this paragraph, I need to explain the first meeting and then this. So in January, Mr. Sissoko arranged for a meeting at IGI. We had a meeting with Advocate J. Govender and another member of the IGI legal team. Where they indicated, yes, they were tasked to do an investigation, but they cannot share their findings with us because of their mandate and the fact that they are regulated by a different act. And their reporting lines are very different. So in essence, there was some words exchanged. So Advocate Govender was addressing me through the meeting. We were discussing, I asked her how many different crime intelligence matters, etc. So she did indicate that they are in the process, they are consulting with witnesses based on certain complaints. She was unable to give me any witness names. She explained safety as well as different mandates. So Mr. Perumal got agitated to a point where Advocate Govender even said to him, your cowboy tactics is not going to work on these cases. We left that meeting. I did say it was a fruitless meeting because we couldn't assist them and they couldn't assist us.
Sorry, you couldn't and they couldn't assist you. What was the purpose of the meeting when you went there?
With IGI, like with other investigations that had been completed previously during the Zondo Commission period, they are able to assist because the report has been completed. But because this was still in the process of investigations, sharing of information could not take place. So, Commissioner and Chair, we left that meeting and Mr. Perumal then wanted to arrest Advocate Govender for Section 34 for not willing to assist us. And there was this whole thing where I had to pull out the IGI Act and explain to him that they have their own. But that's just on a side note. But it was just to give you an explanation of how things were being done.
Can I just interject there? So this is the meeting that Mr. Sissoko also testified about that he attended.
Correct, in January 2025.
And did you obtain any documents at that stage?
No, nothing was shared with us.
And the discussion was about crime intelligence investigations, current investigations that the IGI was investigating?
Correct.
Okay.
Based on complaints that they had received.
Okay, so you leave that meeting and you did report back to Advocate Johnson saying that it was a fruitless meeting, and she says she's not surprised.
Yes, correct.
Okay. And then we now in September.
So we in September, and Mr. Perumal is explaining various things about how Advocate Schlatzwayo, Advocate Siruni, and myself are not understanding the evidence of the Mukwele docket. He then tells us that the minister, being Minister Mkunu, arranged for someone to fly to Eastern Cape to him and provide the IGI reports.
And this is the IGI report that was prepared in respect of the crime intelligence investigations undertaken by the IGI.
Correct.
Which you were told at the time in January they were still busy with investigations.
Correct. And my understanding of those reports is someone very high up has to approve that we share that information.
Okay, so what Mr. Perumal communicated in that meeting was that Minister Mkunu arranged for someone to fly that report, a hard copy of that report, to Mr. Perumal in the Eastern Cape.
Correct.
And the IGI had given that report to the minister?
Correct.
Okay. And in terms of what legislation or powers did the IGI give that report to the minister? Was there an explanation as to, was it commissioned by the minister, a report commission or investigation commissioned by the minister?
It's unclear. I just know that that report was not supposed to come to us in that way.
Okay, do you know it wasn't supposed to come to IDAC via the minister?
Correct.
Okay, and why do you say that?
Because the IGI, I had read the act prior to going to have the meeting with.
Whether Advocate Johnson was aware that he had gotten the report from the minister?
Yes, in my notes, there's, in one of the notes, there is a note, just a note down that says Dylan must call IG. But in this meeting, Mr. Perumal indicated very clearly that the ID is aware that the minister has arranged for this report to be flown to me.
Okay, I'll ask you to find that reference during the lunch adjournment, but for now, so that is what he tells you about the how he got the report.
Correct.
And does he say anything else about the report in that meeting? Because you have a reference that says page 45 to 75. I would assume that's page 45 to 75 of the report.
Correct. It's even part, he's even telling us which part of the report is relevant. Mr. Perumal then WhatsApps me the IGI report.
If we can go to page 600 first, and you tell us why you took a photograph of this. File 10, part 2. This is a photograph of a letter dated 2 April 2025, addressed to the Minister.
Correct.
And it's on the letterhead of the Office of the Inspector General of Intelligence. Before you read the letter, can you tell us why you took a photo of this letter?
I sent it to the evidence leaders to show that we are in possession of an IGI report and all the correspondence, or the correspondence that's attached to it.
Okay, can you read the letter into the record, and then I'll ask, then we can go to the WhatsApp where you received the report.
It's addressed to Minister E.S. Mchunu, MP, Honorable Minister of Police. Dear Minister Mchunu, investigations on matter of crime intelligence in terms of Section 7, subsection 7C of the Intelligence Services Oversight Act 1994, Act 40 of 1994, Oversight Act. Our correspondence dated 24 March 2024 regarding the above subject matter refers.
Just
That
to,
date
I think
must
it
be
should be
25.
2025, yes. But it's not, you're not the author,
I'm not
but
the
it
author.
makes sense that it be 2025. Continue.
In said correspondence, we appraised the Minister on the progress made in respect of the investigation and the outstanding interviews with specific officials from Crime Intelligence Division of the South African Police Services, SAPS-CI. We were advised on the 27th of March 2025 from the Chief Financial Officer, CFO of SAPS-CI would not be available for an interview on the scheduled date due to prior planned leave, and would be available on the 8th of April 2025. Based on the foregoing, we are unable to meet our envisaged date of 4 April 2025 to conclude this investigation without the critical contribution of the above-mentioned official.
And who was the official, the CFO, that was being referred to?
It would be Mr. Lushaba.
Where is the rest of the letter?
I have brought the documents.
Chair,
Sorry?
the witness brought the document this morning with the report. We still need to discuss with the NPA releasing allowing us to use the report. It's the first time anyone has had sight of the report, and she brought hard copies. She didn't send an electronic version. She had received it via WhatsApp as well. This was just the photograph that she had taken initially to show us that she does have it, but she's brought it this morning with her. We will then deal with the I think there's a page 2 which has the signature and
Yes,
a short
correct.
note, so we'll deal with it then during the
So
lunch adjournment.
The report is the letter.
We have this is the covering letter, and there is a 77-page report.
I'm asking about the letter. The letter is incomplete.
Yes, there's a second page, so she just took a photo of the first page, but she's brought the covering letter with both pages and the report itself.
Okay.
Yes. We can go to page 601, which is then the WhatsApp where you receive it, and this would have been, let me just get the correct page. It's not 601, it's 612. Just bear with me. 609.
609.
Chair.
Ms. Nube, you will guide, because you're dealing with the report, you will guide whether this question can be answered on, or is subject to you getting approval. My question is, you've looked at the report. What was the complaint that the IGI was investigating? And I'm happy for you not to answer if it falls under you need to get consent from the NPA. Is it one of those?
I think I would rather, once I get consent, then I'd be able to explain. But at this point, because the report and I don't have the authorization from the NDPP, if I mean, reserve that.
All right, that's fine. Thank you. Thanks.
Thank you, Commissioner Baloy. We'll sort that out during the lunch adjournment. The second page of the letter reads paragraph 5. In this regard, it would be appreciated if we could present our report containing findings and recommendations on Thursday, 10 April 2025. 6, thank you for your attention and consideration of our request. Yours sincerely, it's signed by Mr. I. Faisal, Inspector General of Intelligence. And then it says investigations on matters of crime intelligence, investigation of alleged irregularities pertaining to procurement of buildings, validity of recruitment process, and security clearance of senior member of South African Police Service, crime intelligence SAP-CI. That was the investigation, Chair, but the report hasn't yet been perused until we've dealt with the issues with the NPA. So if we can then go to page 609, this is where you received, this is after the meeting of 1 September where Mr. Perumal tells you how he got the report. And we can see 2 September, this is from him to you at 1451, IGI report PDF, 77 pages. We can confirm that the covering letter is 2 pages and the report is 75 pages.
Correct.
Okay. Now, back to that meeting. He references page 45 to 75, and he must have then had a discussion with you as to what 45 to 75 contains, what it deals with.
It dealt with the portions, yes.
Portions, so more than what IDEC was investigating, or was IDEC investigating more than what the IG was investigating? Or were they identical?
I can't pinpoint exactly how, but I do remember that Advocate Sarunya, myself, and Advocate Schlatzweiler read the report, and Advocate Sarunya also sent an email based on it saying, I read the IGI report and it takes us no further.
And insofar as the IGI report is concerned, we know now that Mr. Perumal gets it through the Office of the Minister.
Correct.
And you say that you know that IDEC is not supposed to get it that way. How were you going to use the report if it was beneficial or if it was corroborative of IDEC's investigation? Was there a discussion about that?
It's the same thing as the email that's a subject heading secret, where somehow, some way, Mr. Perumal got I think it's General Particular's disciplinary assessment report on all the, so it's the Mokwele and the 6 others. So when he emailed it to us, the subject was secret. And so the discussion stemmed that it was going to be used for intelligence purposes, but prosecutors don't use things for intelligence purposes. And I think that's also what stemmed Advocate Surunya's email saying it takes this case no further.
But when he was discussing the report, because you hadn't seen it at that stage, but he was discussing it, was Mr. Perumal saying that it is supportive of IDAC's investigation and the charges that you were pursuing against the crime intelligence officials?
His words were, it's golden.
Okay.
So, yeah.
It was
in support of.
Do you know if Advocate Sarunia also got the IG report?
Yeah, what happened was when, because Advocate Sarunia doesn't like WhatsApp, so it was WhatsApp to me and then printed. So we printed 3 copies for the 3 advocates to work off.
Okay, and so after he then perused that, he said doesn't take the matter any further?
It takes the case no further, yes.
Okay. Then I'd like to move on to...
Maybe before you move off this, you say in the past you have had cooperation with the IGI office in other matters.
Correct.
Ordinarily, what is the process for you to get that cooperation and to get their reports?
It must
for
be
your people?
finalized.
How does it work?
The report must be finalized.
Yes.
And then it must be given to the authority that controls the IGI or requested me, the president, the minister's office or whatever. Okay. But that report is only supposed to be released once it's finalized. Yes. And then there's mutual legal assistance that we would then sit and discuss, okay, portions of this, guys, we're going to have to redact. You can't use it. We cannot disclose it to you. Portions we can disclose in terms of just for you to guide where you might possibly want to go for your investigations. But it would never be the full report. Yes. And it would only be the finalized report.
So just to make sure that I understand, in the normal course, this report that you end up getting by WhatsApp, you say in normal proper course, it would have come from the IGI to whoever is the authority that the IGI reports to, be it the president or the minister responsible for the IGI. And then it would go to IDEC directly or to the Minister of Justice, Minister of Police. I just want to understand how Minister Mkunu would, if things were done properly, how he would end up with this report. To your knowledge, okay, from your experience.
From the way, because the only other matter that's getting assistance from IGI is under advocate law. So when I was going, because I was walking in blindly, I had not dealt with the IGI previously. So when I asked for assistance on how it works, it's a confidential document.
How it's normally done.
There needs to be, so like I was explaining, in the mutual legal assist, you would then agree, paragraph 4, guys, we're redacting, paragraph 5, you may use what we're supposed to prosecute in the Mokwele docket.
I see.
Thank you. Bail amendment and the application, the bail appeal on the
Section
Mokwele
63.
matter. Yes.
Correct. Thank you. Brief Peter and tell him what I have requested.
Just wait first.
Sorry.
6:10, 9 September 2025, the message from Advocate Johnson at 1:11.
So this is after I was called into the office and told. And then Advocate Johnson WhatsApps me, brief Peter and tell him what I have requested. Does he agree? I reply, I will. He has stepped out for lunch as soon as he is back.
Sorry, it's not your fault this time, but could you just move closer to them and raise your voice because there's sound from above. I will. He has stepped out for lunch as soon as he is back.
To which he replied at 13:12, okay. After a conversation with, it was about a 2-hour, maybe an hour and a half.
Even it deals with the different bail conditions. This is still the evening of.
Kindly inform Peter and Joy. I know it's